Counsel, on the second question presented, there is a way of reading that transcript in which one could say the judge basically said, I'm going to impose the condition, come back to me later if you disagree. And then he mentions the right to appeal, that there was permission to appeal at least this condition. Why can't we read that colloquy as such?
Because the district court doesn't have authority to modify the parties' agreement, so...
Well, then that goes to the silence that was the government's position there. All right. What does that do to the ripeness question that Justice Barrett had? Presumably, you would argue at any point in time that the waiver applies, correct?
That depends on the language of the agreement. Here, this agreement doesn't bar a petitioner from seeking modification of the condition of supervised release, so he could do that. The Fifth Circuit has said that an appeal from the denial of modification is covered by a waiver if it's the type of agreement that, if the type of appeal that could have been brought from the beginning.
Isn't that the vicious circle you're putting this defendant in, isn't it?
I don't think we're putting the defendant in any circle. I think the defendant entered into an agreement, and this was the terms of the deal.
Tough luck, because the Fifth Circuit won't let you do it, so we should let you do it. We should let you say it's
It is possible,
unright.
I think, under the terms of the Fifth Circuit's doctrine, that if the type of appeal that he brought were more as applied and not the type of thing he really could have brought from the beginning, given that this appeal waiver doesn't cover appeals from modification, it could be allowed.
You admitted that it would be unconscionable to contract to have a racist judge decide the case, correct?
I admitted it would be against public policy to say my sentence will be decided on the basis of race.
But it's not, in fact, against public policy to have a racist judge sentence you.
Yes, the sentence would be against public policy, but the question is whether the agreement is against public policy. And again, the agreement is not to have a racist sentence.
But that's what
the agreement is to have no appeal, and that the agreement to have no appeal is not against any public policy.
Even though it involves a breach of the duty of good faith dealing, which applies to third parties that you delegate contract rights to.
But a judge is not a delegee under the agreement.
You can't have it both ways. He is either a judge acting in conformity with the law, or he is a delegee subject to the good faith and fair dealing condition. You want to pick and choose defenses.
Not at all, Your Honor. He is a judge acting in good faith in the law, but a presumption of the entire appeal waiver is that the defendant might not think that the sentence he ultimately receives is unlawful. That is kind of the core premise.
But it's not a question of unlawful, because it's a question of whether he's violated statutory rights, whether he has used impermissible constitutional factors, whether he's violated statutory limitations, imposing restitution when the statute doesn't provide for it and the agreement doesn't contemplate it. He's acted outside the bounds of expectation.
The relevant expectation under contract doctrine, again, I'm assuming now we're in contract world, the relevant expectations are not the parties' expectations as to what sentencing outcome will occur. Contracts hold even when unforeseen and unexpected things happen. The relevant expectation is how the parties expected their agreement would operate, whatever the outcome at sentencing.
So why isn't it, and going back to Justice Kagan's question, we all assume that judges will act lawfully? Not that they can't make errors in calculations, but that they'll act lawfully and not unconstitutionally.
We do assume that, but the premise of the agreement here is that both sides might not think that the judge has acted lawfully, and if the defendant thinks the judge hasn't acted lawfully, he can't appeal. That's kind of the whole premise of this agreement here. That is the assumption.
Right. We're going around in the circle we started with.
Justice Kagan.